Hi, good evening, everyone, or good afternoon for those of us on the West Coast. I want to thank you all for being here with us. My name is Yael, and I'm hosting this webinar. I want to start off by thanking all the co-sponsors. So thank you to my brothers in Tulane Phi Alpha Delta Pre-Law Fraternity. Thank you to my friends in Tufi, Tulane University for Israel. Thank you to Orange for Israel at Syracuse University. Thank you to the Harvard Law School Alliance for Israel. And thank you, Camera on Campus, which stands for Committee for Accuracy in Middle East Reporting in America. And specifically, thank you to my coordinator, Sasha, for supporting me this year and for helping me organize this event. I couldn't have done this without you. Thank you to the Lawfare Project, and thank you, Benjamin, for being so patient throughout all of our rescheduling. This event was actually supposed to happen at Tulane University in New Orleans about a month ago. And even though that didn't work out, I'm grateful to have the flexibility to make this event available to all of you virtually. So if you don't know me, my name is Yael Pasimansky. I'm from Seattle, Washington, and I'm a sophomore at Tulane University. I'm double majoring in political science and philosophy, and after college, I hope to attend law school. I'm a Camera on Campus fellow this year, and as a fellow, I have several obligations. Some of these include writing articles about Israel for my campus paper, hosting a writing workshop, hosting an educational event, and overall just monitoring Israel on my campus, whether it be in the school newspaper, in the classroom, or at events. So when I was considering what I should do for my fellowship event this year, I knew that I wanted to combine my passions for law and my passions for Israel, and that's where Benjamin and the Lawfare Project come in. So throughout this webinar, if you have any sort of question, please go ahead and post it using the question and answer feature, which you all should be able to find right at the bottoms of your screens. And Benjamin will be answering some of these questions. And without further ado, so Benjamin Ryberg is the Chief Operating Officer and Director of Research at the Lawfare Project. He received his Bachelor of Arts from the University of Michigan with a double major in economics and organizational studies. And then he received his JD from Cardozo School of Law. He was admitted to the New York State Bar in 2011. And in law school, Benjamin actually co-founded and served as co-president of the Cardozo chapter of the Human Rights Institute, short for CRI. This is a nonprofit organization dedicated to combating major violations of human rights for children around the world. In 2013, Benjamin was profiled in the Jewish Week's 36 Under 36 list of young visionaries. Benjamin has been featured on the radio and television programming, and he has spoken to a range of audience, including APAC Policy Conference, Alpha Epsilon's Pi's International Convention, the Israeli Military of Strategic Affairs Global Coalition for Israel Conference, and many more. So without further ado, thank you so much, and I present to you Benjamin Ryberg.
All right. Well, first off, I want to thank you, Yael, not only for hosting this event, but for your very lovely introduction. Much appreciated. I had intended to go through all the list of sponsors. In the interest of time, I won't, but thank you all. And also Yael and Sasha. This has been obviously something of a nightmare to plan with all the rescheduling due to the health crisis. And you two have handled it absolutely seamlessly. Thank you so much for making this happen. To all of you at Tulane who would have attended in person, I'm very sorry that I don't get to meet you in person. Hopefully we will one day. If after this event you want to be in touch with me about anything, please feel free to do so. Yes, my name is Ben Ryberg. I am the COO and Chief Operating Officer of the Lawfare Project. And the Lawfare Project, simply put, provides free legal services to the Jewish and pro-Israel communities to enforce their civil and human rights. And we do this through what's called primarily impact litigation, strategic lawsuits aimed at affecting social change that benefit not only our individual clients, but these communities at large. So in a nutshell, the Lawfare Project fights discrimination and anti-Semitism wherever we see them, whether it's commercial discrimination or BDS, whether it's unequal treatment of Jewish students on campus, of Jewish employees in the workplace, or even state-sponsored discrimination, such as when governments actually enact legislation, state-sponsored discrimination, which is where governments enact legislation that treats Jews and Israelis differently. And that's a smattering. We do much more than that, but that gives you some sense of what we lawyers at the Lawfare Project do on a daily basis. So first I want to talk about a few of the Lawfare Project's major cases so that you can get a sense not only of what we do, but more importantly, how for those of you who are lawyers, but perhaps not doing human rights work or who are or civil rights work, those of you who are aspiring lawyers, so you understand how the law can be used strategically to enforce the rights of minority groups. And also for students who may not be pursuing the law or may not be interested in that field, may not be at that stage in their academic career yet, to give you a sense of how the law works, particularly with respect to student civil rights on campus in the face of the tremendous amount of anti-Semitism and anti-Zionism we unfortunately see. After going through some of the cases, I'm then going to get more into the issues of students' rights and discussing specifically the key laws that I think all of you should know about. Excuse me. All right. So, and there will be plenty of time for Q&A. So, starting with some of our major cases, Kuwait Airways. This is, not surprisingly, based in Kuwait, owned by the Kuwaiti Kingdom. And several years ago now, it came to our attention at the Lawfare Project that Kuwait Airways will not sell you a ticket and fly you on its planes if you have an Israeli passport. They will not fly Israelis. Now, when we learned about this, as you might imagine, we were incredibly shocked because just from, not even from a legal standpoint, but just from sort of a clear-headed, rational standpoint, we realized if any other group was being discriminated against by a major air carrier or any major company in this manner, if, for example, Delta developed a policy saying, no French people can fly on our planes, there would be outrage, and more likely than not, the business at issue would be out of business. But this was not so. Kuwait Airways had in fact been carrying on this policy and operating in the United States, having flights that go to and from the United States for more than 30 years. And somehow this was just being left to go on. So we found first that this had been raised at some point with the Department of Transportation, but they had just sort of put it off, in part because they were presented with some legal arguments that they really didn't accept. And so what did we do? We thought there has to be something here. I mean, this is flat out discrimination. Again, any other group, this would not stand. Why is it okay that this happens to Israelis? So we spent a tremendous amount of time doing legal research, and we identified, among other laws, a federal law that says that prohibits unreasonable discrimination in air travel. Now, not to get too far into the specifics, but the flight at issue here was a flight between New York's JFK Airport and London Heathrow. So, and this is important because all the other flights going to and from the United States that were handled by Kuwait Airways all went through Kuwait City or other Arab League destinations that do not recognize the Israeli passport as a valid travel document. This is part of the Arab League boycott of Israel. Now, so this would be an excuse perhaps for the airline not to fly people in and out of the United States. Perhaps not, but they're saying we don't recognize the passport. That means if you want to fly here, you can't get off the plane and go through customs. So this is a legitimate excuse for us. So we left that alone for now because we saw there was this one route that was their most popular route at the time, mainly because it was incredibly inexpensive, between JFK, New York City, and London, that didn't implicate this issue of whether countries do or do not recognize the Israeli passport. You can travel into the United Kingdom if you have an Israeli passport. You can travel into the United States. So this should not have been an issue, and they should not have been able to continue on with this practice for as long as they did. So we contacted the Department of Transportation again, and we presented them with this law and said, what could be more unreasonable than refusing to sell to somebody, arguing that it's because your country doesn't recognize this passport. Meanwhile, your country's borders are not implicated here. So we waited around for quite some time, and ultimately, lo and behold, Department of Transportation decided they agreed with us. They accepted our legal arguments. and they ordered Kuwait Airways. They said Kuwait Airways is in violation. So we said, well, that's all well and good, but unless something is done about it, this is just going to continue on. So then we went to New York, the Port Authority of New York and New Jersey, which is the landlord for John F. Kennedy JFK Airport. Said, we found their lease. We said, look, we looked through your lease. There are provisions here that any airline, any that's renting space for runways, for ticket booths, et cetera, from you, they have to follow the laws. And if they don't follow the laws, they are in violation of the lease, and you're supposed to terminate it and kick them out, not let them use your airport space anymore. So we worked with them, and then Port Authority, to our delight, issued a cease and desist order, telling Kuwait Airways that either they needed to stop discriminating against Israelis, come into compliance with the law, or they'd have to get out. So what happened next was unexpected, but not at all unproductive. My colleagues and I actually went to JFK Airport with an Israeli woman who was going to attempt to buy a ticket on that flight route to see if the airline was still discriminating or not. And when we got to the ticket counter, the ticket agent took a look at the passport and went away for a few minutes looking a bit concerned, came back and said that flight route, the JFK, New York, London, Heathrow flight route, has been canceled indefinitely. What did this mean? We found out that the airline had decided to stop its most popular flight route rather than fly Israelis. Ultimately, they were then in compliance with that law. So we had stopped this form of discrimination. We are now looking at how to possibly take it further, whether there are other flight routes that go through Arab League countries are implicated. But this was a major success. So then we went to our network of attorneys. We have, over the years, just as an aside, put together a network of 400-something attorneys who work with us on cases that they think are important and, again, impact litigation. And we first approached one of the attorneys we work with in Switzerland. Said, we found that there are flights between Switzerland and flights in Europe. I'm forgetting which routes go to what, but there were Switzerland, Germany, Italy, and France. And there were flights on Kuwait Airways between those airports that did not, again, go through Arab League countries. So we said, all right, we have a similar situation here where the airline is flying between these two places that are not Arab League, that totally recognize the Israeli passport, but they're not willing to sell tickets. We've tested it out. We went on their website. You cannot buy one if you try to enter it with an Israeli passport. Do you have any laws here that can, under which they can be held accountable? And in Switzerland, they did. So we worked with our attorney, filed suit in Switzerland. The next day, Kuwait Airways announced that it had canceled all of its inter-European flight routes, and they remain canceled to this day. I'll wrap up this portion on Kuwait Airways by telling you that we are now litigating against them in Germany and in the UK to go after their flights that go between European destinations and destinations outside of Europe, but not terminating in Arab League countries. So now moving on to a case that is sort of the epitome of BDS, boycott, divestment, and sanctions. First, I want to say something about BDS. A lot of people kind of look at it as a move. They call it a movement. They call it freedom fighting. They call it, advocacy or activism for the Palestinian people. Without getting into too much depth now, what BDS is commercial discrimination flat out, and in many cases, unlawful commercial discrimination. Refusing to do business with someone, boycotting somebody because of who they are, because of their race, their ethnicity, their religion, their national origin here, their citizenship in some places, that's illegal. Again, if you go back to the parallel I drew earlier with Kuwait Airways, if I was let's say I had a store and a company wanted me to carry their products and sell them. If I have a grocery store and someone wanted me to carry bread, and that bread was made in Mexico, let's say, and I said to them, no, I don't want to carry your bread. I don't want to do business with you because it's from Mexico, because you're Mexican. That would not fly anywhere. Again, there would be public outrage like you wouldn't believe, and that grocery store would probably cease to exist. Again, however, the world does not or has not seemed to view such discrimination against Israelis in the same way, which is really unfortunate. So the point is, BDS, if you're not already, please call it what it is. It is unlawful commercial discrimination. one more point I want to make. When I say that, I'm talking about actually implementing BDS, refusing to do business. I'm not talking about advocacy of any kind or of encouraging people to boycott. They're encouraging illegal discrimination, but that in and of itself, the encouragement, that is free speech. So coming back to the National Lawyers Guild. The National Lawyers Guild is according to them, I believe they said, the oldest progressive lawyers association in the country. They devote a phenomenal amount of time to demonizing Israel and Israelis, more seemingly than much of what else they do. And it came to our attention that an Israeli organization had attempted to place an ad to buy ad space in the National Lawyers Guild's annual dinner journal, sort of a booklet that goes out when they have a gala. And this ad just said, "Congratulations to the honorees," listed the name of the company, State of Israel, and that was it. It was largely identical in every way to all the other ads that were submitted from various lawyers, from other organizations, etc. So this organization that tried to buy this ad, shortly after they submitted and paid their $200 to buy the ad space, they received an email from and signed the National Lawyers Guild national office that said, basically, unfortunately, we have a policy, an organizational policy or resolution that prohibits us from accepting money from Israeli organizations. Therefore, we're returning your $200 and you can't have the ad space. Again, I'm not going to keep repeating about my comment about if this was anybody but Israelis, there'd be outrage. I think everybody gets that by now. But again, this is flat out discrimination based on protected class, based on national origin. And in New York, there is a law that says specifically you cannot boycott, blacklist, refuse to do business with, et cetera, anybody, whether it's a person, whether it's a business, because of their protected class. And this law has been on the books for years, but we'd actually never seen it used in the context of implementation of BDS like this. And in fact, to our knowledge, the Lawfare Project was the first organization to identify this argument that this law, it may not prohibit BDS advocacy, but it absolutely prohibits conduct in furtherance of BDS, discriminatory business conduct. We'd identified this several years beforehand when a food co-op in New York was being pushed to stop selling, to boycott Israeli products. So shortly thereafter, the National Lawyers Guild was served with a lawsuit saying, you have violated New York City and state laws. You have engaged in unlawful commercial discrimination. And we are now in the process, we're in the pretrial discovery process of that, but we are very confident in our case and are working actively to move it forward. A few others before I move on to the campus matters, excuse me. This is not so much litigation, but another aspect of what the Lawfare Project does. Over the years, in very recent times, unfortunately, we've seen a pretty dramatic increase in anti-Semitic hate crimes. So we now provide counsel to victims of such hate crimes to help them get their assailants prosecuted, and not only prosecuted, but prosecuted for hate crimes. Oftentimes we see Jews, Israelis being attacked, but for one reason or another, district attorneys do not decide to prosecute for hate crimes. And there can be a reason for this at times. It is much harder to prosecute a hate crime than a regular crime. You have to show that an animus against that person was some part of the motivation of the crime. But nonetheless, there are some examples, like the one I'm about to tell you about, where it's abundantly clear that that element, that anti-Semitic hateful motivation exists. So this case involved a woman named Lihi Aharon, an Israeli student who was riding the subway in New York City a couple months ago. And she was there with a friend, and a woman started attacking and yelling nasty things at an Orthodox Jewish man who was dressed up accordingly and could clearly be identified as an Orthodox Jew. And this woman, Lee, said something to this woman, told her to stop. And the woman started hurling the most disgusting anti-Semitic epithets, really foul language, and ultimately attacked Lee, assaulted her, and scratched her face. There's a picture online that's been run all over the news concerning this case that shows what happened in this attack. And so, like many people, Lee had no idea what to do about this. I mean, she went to the cops, but who knows whether they're going to do anything. She didn't know how to pursue this, but she knew that something needed to happen, because if no action was taken, then crimes like this were going to continue. We were already seeing them rising. If law enforcement and the district attorney is not doing anything to hold these people accountable, why should we expect any sort of decrease in them? So we worked with a counsel at another firm who we work closely with on these hate crime cases. And first we helped Leahy make sure that her assault was fully reported properly and that the district attorney took it up. But then the district attorney initially decided that they did not want to prosecute it as a hate crime. We don't know why, but we thought this was patently ridiculous. The words that were coming out of the attacker's mouth, undeniable that the Judaism here was a motivating factor. So we worked very hard, and ultimately we were able to convince the district attorney to reverse course and prosecute it as a hate crime, and the assailant was now indicted on hate crime charges. One more recent case, excuse me, in Ann Arbor, Michigan. For the past 16 years, there's a synagogue there, and every Saturday when congregants come to services, there is a mob of protesters right outside holding up signs and yelling at these the congregants, yelling things and holding up signs that say things like "Jewish power corrupts," "Zionism is racism," resist Jewish power," horrible vitriolic anti-Semitic expressions. And I should say that these people, according to a city ordinance, what they're doing is illegal. They would be allowed to protest in a different location further away, so they're not directly interfering with the ability of the congregants to go to services and harassing them as they go into worship every Saturday. But the city has done nothing. So now we have commenced litigation against the city to ensure that to hold them accountable and to hold the protesters accountable, ideally to ensure that these city ordinances like this are enforced vigorously in the future to protect people who are engaging in their religious practices. And I think this case is particularly important also because if this can happen to Jewish people going to shul, this can happen to individuals of any religion, any religious minority or majority even. So it's incredibly important with all these cases. This is why the Lawfare Project exists, to adamantly enforce and call for the enforcement of civil rights laws. Even if some of these cases more directly affect Jewish individuals, for example, they ultimately affect the climate of the entire country and the upholding of civil rights law, which helps all of us. Now I want to turn to some of our cases involving campus issues, and I'll go through this a bit quicker than I had initially intended to. So I want to preface this also by saying the goal with any of these cases, I don't want to say particularly with campus cases, but that is sort of how I personally feel. The goal is never litigation, to go into court. Our goal when we take on a case at the Lawfare Project is to right the wrong, is to stop the problem, to deter future problems. If we can do so by without having to file a lawsuit, without even having to send a lawyer's letter, if we can be counseling students behind the scenes on how to follow the appropriate channels to enforce their rights, to deal with administrators and faculty, et cetera, and that leads to the result that we want, that leads to the protection of that student's rights and their ability to exist on campus and be treated equally as all other students, then our goal has been met. Again, though, the goal here is never to file a lawsuit and to end up in the courtroom. I think that's a common misconception of lawyers in general, and I think it's important to set the record straight. So some of our earlier cases that were dealing with issues at campus, but not so much civil rights, about 10 or so years ago, maybe 9 or 10 years ago, we learned that Rutgers University, a student group there, BACA, BACA, Students for Middle Eastern Justice, which is very similar to Students for Justice in Palestine, they were hosting an event that was intended to raise funds for a flotilla. The point of the flotilla was to sail a ship and break through the Israeli naval blockade, and ultimately, according to the flotilla organizer's own website, to bring various resources to Hamas. Hamas is a US designated and designated by other countries, including in Europe, I believe Canada and elsewhere, as a foreign terrorist organization. For US purposes, under US law, what that means is you cannot help them. We have designated them as the enemy, for lack of a better word. You cannot give them money. You cannot, and I say you, I mean people, businesses, anybody. You cannot give them various supplies. You cannot give them expert training to teach them how, how to build weapons, let's say. Basically, you cannot help them whatsoever. If you do, you violate federal law by providing what's known as material support. So here we have a situation where a student group on campus was holding a fundraiser, and the organizers of this flotilla, who the funds were supposed to benefit, they were very clearly saying that these funds were meant for, the funds were meant to help Hamas ultimately, whether it was directly giving them the funds, whether it was buying various items, building supplies perhaps, and giving to them, we don't know. But this was their stated goal. So we did quite a bit of research, and we looked into the laws on material support, which I basically just outlined for you. As a person in the United States, you cannot provide, again, material support or resources, money, and a whole slew of other things to designated foreign terrorist organizations. We put all this together. We sent a letter and memo to the president of the university, probably to put him on notice, and that notice meant that now, if he was to let the funds go, and those funds did indeed get to Hamas, he could be on the hook for violating federal law. So we waited around to see what happens. We didn't hear back directly from the president, not surprisingly, but ultimately we were informed that the funds had not gone to their intended recipient. So part of the reason I think this is an important example is because, again, it emphasizes how a carefully crafted, compelling legal argument that can get the job done. Again, there was no need to start referring this to the authorities. If you inform people about what the law says and does, not only about how it protects them, but also how they may risk running afoul of it. At times, I would hope more awfully than not, people will act in their own self-interest and do the right and legal thing. Okay, a few other campus examples. Boston University, a student there who was a very outspoken pro-Israel advocate in class, and one of his professors, where he often spoke about his views on Middle Eastern issues, this professor just treated him terribly. It was very clear the professor did not like him because of his Zionist views, whether or not the professor was anti-Semitic or knew that he was Jewish and did not like him because he was Jewish, we don't know. But certainly because of his professed Zionism, this professor made it abundantly clear that that was a problem for him. This professor would berate the student in class. He would he'd yell at him. He kicked him out of class. Ultimately, all of this came to a head, though, when the student showed up for his finals. Now, this student had been approved by the school to get extended testing time due to an emotional matter, a mental condition, whereby he needed more time to complete his tests, and also he would get a separate room, things like that. He'd gone through the appropriate channels. He was approved. He got this with all of his other classes. There was no problem. On the day of the exam for this class, he showed up and was told that he would not be able to take his test under these approved accommodations. He wasn't told why. He was just told, nope, not happening. And ultimately, he did very poorly, markedly poorer in that class than any other classes. And he came to us about this and said, yeah, I'm partly upset about the grade, but I'm also just upset. I'm very confident that I was treated this way because of my expressed support for Israel, Israel's right to exist as the Jewish homeland. And again, a case for litigation did not come into play at all, did not have to come into play. We worked with the student totally behind the scenes and helped him liaise with the proper school offices. Ultimately, the grade was expunged, and that professor after that semester is no longer teaching at that university. So I want to get into now, as we're as usually happens when I speak, the time goes by faster than I think. I want to talk a bit about our case against San Francisco State University, which was really a landmark case, not only for the Lawfare Project, but also for Jewish students, Jewish individuals worldwide. So several years ago, I'll start at the beginning. I'll start way back. For years and years, we learned this later on, San Francisco State has been a bastion of anti-Semitism. And had actually gained a reputation for being the most anti-Semitic, unfriendly toward Jewish students university, academic institution in the United States. But we, we'd seen that thrown around. We didn't really realize how bad it was. So there were two events. The first event involved a Hillel-hosted event featuring Nir Barkat, the former mayor of Jerusalem. Mayor Barkat showed up to speak. A group of protesters came into the room, started screaming things like "Intifada, Intifada, get the F off our campus, from the river to the sea," which we'd think most people, if not everybody on this call, knows what that means. It means they want to wipe Israel off the map. And they became so loud, they were encroaching on the crowd. They were yelling louder and louder using sound amplification devices that the event could not go on. The mayor first got into the center of the audience trying to enable people to hear him. Ultimately, it was so chaotic and people were afraid because of what the students were doing that the mayor had to leave. Now, what was really shocking about this and what ultimately paved for the way for the case, though, was that campus police were there. The chief of campus police was there, as was an administrator. And it later came out that, according to our plaintiffs, our client, a student who had organized this event, that the campus administrator had told the head of campus police to stray from normal practices, which would have been to remove the protesters and take them to a designated protest area, and instead just said, let him go. Let him be here and shout down the event. Again, this was what catalyzed the way for the suit, because the administrator actually intervened and changed the course, stopped the police from engaging in the normal procedures. But and then the second event involved Hillel being excluded from a Know Your Rights fair for minority groups on the grounds that they're Zionists and Zionism is political. Not looking at the fact that it's a core component of Judaism and that this was effectively discriminating against Jewish students. Hillel was the only Jewish organization on campus, but instead kind of trying to paint this as, no, it's political views. If you're Zionist, that means that's a different political stance, has nothing to do with your religion, and therefore we can keep you out. Now, so we filed suit, but we looked at this, we learned about this history of institutionalized anti-Semitism. We learned that students regularly faced racist slurs and epithets on campus. They were refused to wear Stars of David or their yarmulkes on campus. Students felt physically threatened walking around. And the president of the school, the then president who left the school after the filing of our lawsuit, had even suggested that the physical safety of Jewish students was really nothing more than a political issue. Meanwhile, this same professor is on video praising a very anti-Israel group called GUPS, the General Union of Palestine Students, which was the key disruptor at the Nir Barkat event. And the president has been on film saying that GUPS exemplifies what the San Francisco community should be. So he's praising this group that shouts down events and infringes on free speech rights of Jewish students, but at the same time says that Jewish students, they have too much access to me. I don't want to deal with them. So we don't have time to go through the laundry list of decades-long instances of anti-Semitism, but suffice it to say, we put all this together and we said something has to be done. So we filed suit we filed two lawsuits, federal and state, arguing violations of the First Amendment, free speech rights, the Equal Protection, 14th Amendment, as well as California law prohibiting discrimination. And ultimately, while we were planning to go to court, the night before trial, the school, in fact, the entire California State University system, of which San Francisco State is a part, came to the table and said, we'd like to settle. And this settlement, our minds were blown. The settlement was incredible. First and foremost, what they agreed to was issuing a statement that affirms for the CSU system that it understands that Zionism is an important component of the Jewish identity. Why is this important that they're acknowledging this? Many people on this webinar may take that for granted. Of course, Zionism is a core component of the Jewish identity. This means that going forward, people cannot be excluded from events or otherwise discriminated against because they are Zionists. It is no longer just a political view. Now, discriminating against Zionists in the California state system is tantamount to discrimination based on religion, which is prohibited. Among other things, the school was ordered to hire a coordinator or they agreed to rather, hire a coordinator of Jewish student life. They had to get an external review of their policies regarding the application of anti-discrimination policies in the student code, essentially deciding that the school clearly couldn't handle it themselves. They needed to have an outside entity come and help them. Religious discrimination complaints were taken to an outside investigator for the same reasons. The school had to allocate $200,000 to support educational outreach efforts to promote viewpoint diversity, including but not limited to pro-Israel and Zionist viewpoints. And lastly, and this may not seem quite as big, but it actually was very momentous, the school had to allocate space on campus for a mural to be installed, paid for by the university, that would basically be designed by Jewish and Zionist students. And the reason this was so important is because many minority groups on campus had gotten these murals over the years. And over again, Jewish and Zionist students had tried to get their own mural, but had been, and I kid you not, made to jump through hoops that nobody else had to jump through. Our clients, these students, told us things like they had to, the general rule is you had to get X number of signatures to get a mural. But for them, it was exponentially increased. There was always a reason, always some obstacle put in their way of having this mural. So again, this was very symbolic in part, not only because the school now is following the rules and treating these students equally along with all other students, but in addition to that, the students, the Jewish and pro-Israel students, can finally have this visual representation of themselves, of their minority group that they had been denied for so long. So I'll leave the cases there. I could go on for much longer, but I do want to spend a bit of time on getting to the laws that I think are most relevant for civil rights, to protect the civil rights of Jewish students and Israeli students, of Zionist students. And again, these laws are relevant to anybody of any a member of any minority group who is facing violations of their civil rights. That law is Title VI of the Civil Rights Act of 1964. And the other key law I want to discuss, and this is particularly relevant to those who are student advocates, is the First Amendment. So Title VI of the Civil Rights Act, what it says is it prohibits discrimination in places of, in any institution that receives federal funding. That includes public schools, it includes most private schools, any that participate, for example, in student loan programs. There are very few academic institutions in this country, higher level academic institutions, that do not fall within the ambit of Title VI. And it says that, that you cannot be discriminated against based on your race, color, or national origin. You'll note that religion is not specifically included, but since 2004, Title VI has been interpreted to also protect Jewish students against discrimination based on their ethnic or ancestral background. So it has been read to provide protections for Jewish students as well as students of all these other minority groups. And what does Title VI do? What does it mean to say there can't be discrimination? Well, the key kind of discrimination we see that is prohibited under Title VI is a severe and pervasive hostile environment. What this means is severe and hostile harassment, discrimination, etc., targeting members of these protected groups. There's not a clear line as to what constitutes severe and pervasive, what constitutes hostile environment. It is very situational by situation, very case by case. But certainly when we've, some of the cases that we've seen in the San Francisco State case, I think very much fall within this category. When Jewish students are actively excluded from participating in events that are open to all other minority groups, when they are afraid to walk around on campus, there's a good chance that Title VI is being implicated here. So if discrimination, yeah.
We're actually gonna stop and do a few questions right now.
Sure.
Because we're running out of time. We wanna make sure everyone's heard. So the first question is by Zach. He's asking, will Kuwait Airlines fly Arab citizens of Israel, or do they only discriminate against Jewish Israelis?
So we don't know because we haven't been in any contact with an Arab Israeli who has tried to fly. If you want, yeah, no, we haven't seen that happen. I mean, they say we do not fly anybody with an Israeli passport. I believe, unless I'm mistaken, that they would not fly an Arab citizen if they only had an Arab individual citizen of Israel, if they only had an Israeli passport. I believe that's right. So yes, that does mean that other people also, other than Israelis, would be discriminated against by this policy. But clearly the overwhelming majority of those who are discriminated against by this are Israelis and therefore Jews.
Okay, thank you. So the next question is by Joseph, asking, is there a possibility to use the tax code to see if universities are violating their tax exempt status by not protecting free speech of pro-Israel students?
It's possible. It's certainly possible. I would say, again, I don't like, no lawyer will make blanket statements. So if there is a particular, I would want to look at the particular university, but more importantly, what that university was doing as far as prohibiting that kind of expression, Israeli or Jewish advocacy, let's say. But yeah, certainly I think it would be possible, and more than that even, it would very likely be a violation of the First Amendment. Public schools are not allowed to prohibit speech just because they don't like it without certain legally accepted reasons.
So the next question is by Naomi, asking, what would you respond when people are saying that boycotting Israel is kind of like boycotting South Africa?
I would say that the situations are entirely different. So I will say that this is a very long. It could be a very long answer. Israel is not an apartheid state. If you look up that term and look at how Israeli society functions, how the government functions, how the laws function, citizens are treated equally there. That there's simply no parallel. The term apartheid has been totally distorted and misapplied here, unfortunately. And I have a colleague who actually grew up in apartheid South Africa, and is not Jewish nor Israeli, but now speaks on this very topic based on her own experiences, to point out how absurd it is to compare the two. Unfortunately, when you use a term like that enough, and nobody questions it or doesn't loudly and actively question it and challenge it for however long, then people start to accept it and buy into it. But no, there were two sets of laws. Laws were applied totally differently to different groups in South Africa. That's simply not relevant to how it is in Israel. I would also add that we have not seen BDS efforts. This is an important point. BDS has not shown to actually help Palestinians. What we have seen it do is lead to the closure or the moving of Israeli-owned businesses that work beyond the Green Line back to within the Green Line, such that, and these were businesses such as SodaStream and others that employed Palestinians. And that Palestinians have gone on record saying they liked working at them, and more important than they liked it, that there were no comparable jobs that paid them the same once Israeli-owned businesses pulled out. So when we see BDS actually have a concrete effect like that, the effect more often than not is not major on Israel, and it's very harmful to the Palestinians. Another thing is that while the National Lawyers Guild, for instance, did actually effectuate BDS in its refusal to sell ad space, as I mentioned earlier, more often than not, we see entities, companies that are approached and pushed to implement BDS policies. More often than not, they say no. I mean, the Lawfare Project has counseled a number of these companies on the laws that exist that they would risk running afoul of if they implemented BDS. So perhaps, again, it's out of their own self-interest. They don't want to risk being held liable for commercial discrimination or not. We don't know what the reason always is. But most of these companies do not actually implement BDS. So there is not really an economic impact on Israel. So this whole idea that we're having this effect on Israeli governmental policies, I would challenge people, BDS supporters, to show how they are. What they are having an effect on is locally, they are fomenting anti-Semitism and anti-Zionism, which is exactly what we see on campus. BDS supporters are going out and targeting, harassing, threatening Jewish students who are supporting Israel's right to exist as the Jewish state. And I'll leave it at that.
Okay, so our next question is from Danielle asking, do you work at all with the ADL?
We have, we don't work directly with them, but we've certainly dealt with them on various issues. We just have somewhat different focuses. Ultimately, both organizations focus on protecting the Jewish people. The ADL, at least to my knowledge, is not, they're not a legal entity. They're not engaging in impact litigation. I believe they used to be more focused on that, but you know, we're very focused. And if there was an area for overlap, I would imagine we would be open to it.
So next, Gregory is asking, can you talk to the new anti-Semitic California education standards, which are going through despite initial assurances that they will be redrafted? What can be done legally to stop them?
So we were tracking that. I have to say I'm not sure which stage they're at. Gregory, if you want to connect with me later on, I can bring myself up to speed because it's been a while since I've looked at them. My understanding was that they were being redrafted, although the expectation was that they would not be, they probably wouldn't be much better, if at all better. So it really depends on what they look like. And I hate to give vague answers, but again, without seeing specifically what the new draft looks like, I did see the old one. The old draft, I think it was, for most people, I think it would not be viewed as outwardly anti-Semitic. For people who know more about BDS, for example, know about some of the individuals who are named as experts and the positions they take and what they do, how the anti-Semitic views they espouse, then I think it's much clearer. So it really depends on how it's implemented. I don't want to tell you that there's no legal action to go against it. I certainly think that that contacting state representatives, much as that might not sound like the most exciting way to go, but you know, hardcore pushing lobbying efforts for the relevant state Board of Education, Department of Education, I can't remember which, certainly you know, groups should be coming out and pressing them very hard to, you know, if this does need significant any revising. I know that when the first round, when it was decided that it was going to be scrapped and redrafted, that came right on the heels of a number of Jewish and Zionist organizations expressing their extreme disgust with the curriculum the way it was written. So it may depend in part on if it's passed on how it's actually implemented, but again, if you want to connect with me later, I can catch myself up on what's developed with that.
So Robin is asking, have you worked on any cases in Canada, and how would you compare Jewish/Israeli issues between the US and Canada?
So Jewish, Israeli, and Israeli issues as far as anti-Semitism and anti-Zionism are unfortunately the same hatred exists everywhere. I obviously wish that weren't the case. But we have dealt with issues in Canada. I should say that I'm a U.S. lawyer. I'm a lawyer admitted in New York. I know New York law. I know United States law. I've become familiar with some of Canadian law because of the cases we've taken on, but those cases are handled by our attorneys, attorneys we work with in Canada. So yeah, actually recently, we had a situation with at York University where an organization called Herut Israel, I believe, on York's campus, Zionist organization, they hosted an outside group called Reservists on Duty, former IDF members who, reservists, who come in and talk about their experience. And this was met with another virulently anti-Semitic protest. The report said and the students we talked to said 600 something protesters showed up and were shouting things at the Jewish students about, you know, getting into the ovens, stuff like that. And so this was horrible. I mean, people were students were escorted off campus, Jewish students, because they were fearing for their safety. And the reason we ended up getting involved was because the school, York University, initially decided to suspend the official club status for both Herut and for the group that it was found to be leading the protest. And we thought that was absurd. I mean, this is not the opportunity to start treating everybody equally when everybody didn't behave equally. You have one group that was, you know, exercising their rights to host an event, another group that decided to have that event shut down and intimidate and you know, hurl epithets at these students. So taking what I think the school may have thought was the easy way out and saying, fine, we're punishing you both and washing our hands of it was not acceptable. So we did engage our attorneys in Canada, in the area, and excuse me, and ultimately working with the school. It didn't have to get all the way to litigation, but ultimately the school did reinstate Harut. So that's again, we don't want to get to litigation. We want the students, our community, to be protected. That's one example. There's others, but I should get on to any other questions.
So for our final question, what avenues do students have to pursue if they are facing discrimination?
Okay, that's a great question. Actually, I'm sorry I ran out of time earlier discussing Title VI and discussing the First Amendment. So if you're facing discrimination, or if you think you're facing discrimination, one thing I always say when I'm talking about these laws, which I didn't get into enough, is that I'm telling students about these laws with the hope that they can identify when situations exist where maybe there are violations happening. We do not expect students, even if they're law students, to suddenly be lawyers, to sit there and evaluate, here is my case, here are the elements of my claim, I can bring myself to court, obviously. So, but the point is for students to at least have some sense of, wait a minute, the school told me I wanted to have an event, and the school told me that I can't have that event because it involves some Israel-related issue, but they didn't give me any reason, or the reason was because it was controversial, which is not an acceptable reason under the First Amendment. Or if students, again, are afraid to go to class, if professors are harassing students in class because of the professed Zionist views, because they're Jewish, and the school is turning a blind eye despite being notified to it, these are situations where the radar should go off. Say, something may be happening here. If that's happening, come to the Lawfare Project. That's why we exist. That's why we have this vast network of attorneys. That's why we have our full-time 4 attorneys in the office, and we will work with you. What we do is, I'll briefly lay out how this works. You come to us with an issue. First of all, we can have a conversation. You can decide you never want to talk to us again. You're not interested in pursuing it further. That's it. I hope that's not the outcome, but I don't want any students, and I always make it a point to emphasize this. Students should not feel like by calling us up that they're signing up for some major lawsuit. If that is appropriate, give it under the facts and the relevant law. And if the students, if we think there's a solid, very viable claim, and if the students want to go that route, then yes, it can happen. And we provide excellent counsel, including from, again, our network of attorneys who do work for us pro bono. But that's never, calling in alone does not mean anything. And it doesn't obligate the student to do anything. So what happens is you call, we will discuss what your issue is. We will get as many of the facts as possible, ask you a bunch of questions. And then if we can give you an answer right then and there, a legal assessment, we will usually require some consideration and discussion internally. And what we're looking at is whether you have a claim, whether it's an Office for Civil Rights OCR claim under Title VI for discrimination, whether it's a First Amendment claim, whether it's something else. And then we'll tell you, we think you have a claim, and we think it's very strong because of this. We think it's not so strong because of X, Y, Z. Can you give us more information that might address these issues? Or whatever it may be, depending on, again, the facts and the law. And then we'll tell you and explain, perhaps overly thoroughly, what your options are. So, do we think this is appropriate for an OCR complaint? Do we think this doesn't really reach the legal level yet, but we can help you, again, either outwardly or behind the scenes, to work with the school, with relevant campus officials to try to address this problem. We give a lot of my time is even spent just giving sort of best practices and practical tips to avoid situations getting to that illegal level, who the right people are to go to about incidents of discrimination, how to document meetings with faculty or campus officials properly, how, if you see something on campus, when you can record it, what you can do with that recording, and stay within the bounds of the law, all those kind of things. So what I would say is, if you're dealing with any of these issues, first of all, I really do suggest you come to us sooner rather than later. And that's not, again, because we're jonesing to jump into court. It's because partly we want to help try to diffuse and eliminate the problematic situation before it gets that bad. But also one thing to consider that is quite important is statutes of limitations. I'm sure all the lawyers and law students are very familiar with that term. For those who aren't, it means that for specific claims, including Office for Civil Rights claims, but pretty much every claim out there, if not every claim, there's a certain amount of time during which you can pursue that claim. After that time, except in some narrow circumstances, your opportunity to sue, your opportunity to file a discrimination complaint has gone away. Basically, you waited too long. And that's unfortunately happened in some cases where we think otherwise, if the person had come to us sooner, we would have been able to help them. They would have had a very strong claim, but it doesn't matter how strong your claim is if the time has passed. So even if it turns out that, someone comes to us and we say, no, we don't think there's enough to meet the legal threshold at this point, it's still good that they have done so, and that they have not missed that statute of limitations, and that if more things come up that might push it over the limit, that they know that they can come back to us.
Thank you so much, Benjamin. That's about all we have for today. Just really quick, could you let people know how they could reach out if they have further questions?
Absolutely. Well, again, thank you to the host, Yael, Sasha. Thank you so much. Thank you to everybody who joined tonight. Again, I'm sorry I didn't get through everything I wanted to. If you have questions or if you need legal help, this is what we do. You can reach us. Our website is www.project.org. And or you can email me, ben@thelawfareproject.org. There's a page on our website specifically for campus matters that you can fill out a form describing your situation and submit it to us, or you can email me directly. Phone numbers on the website. We're very accessible is the short answer here.
Thank you so much, Benjamin. So that's all the time we have for today. I just want to say thank you to everyone who came on tonight, and thank you so much, Benjamin. I encourage everyone to visit the Lawfare Project website and also to visit the Camera on Campus website for a lot of great information about this. So thank you so much.